Hello and welcome. As you just heard, my name is Eric Sipe. I am Hamla's U.S. National Organizer, and I am so excited to be here to talk about this very important topic, which was stated in the session description. But it's commonly understood that technological advancements are often far ahead of law and policy. And it seems like we're living in a moment right now where governments and institutions of power are trying to take stock of the latest technologies and understand how to regulate them to protect folks, to ensure that human and digital rights are being respected. And many of these big tech companies that are creating our global digital space are based in the United States. But it seems like a lot of these efforts to regulate are happening outside of the United States. So that leaves many of us wondering, what does that mean for those of us in the US trying to hold big tech to account? It's a big question, but I'm so lucky to be joined by some amazing panelists to help us walk through this. So as you heard, Ramsha is the Senior Policy and Communications Associate at the Global Network Initiative. Emma is the director of the Free Expression Project at the Center for Democracy and Technology, and Evan is a director at Fight for the Future. And it's so lovely to have all of you with us today. Before we jump into the discussion, I just want to remind folks that you can put comments and questions in the chat, and we will try to get to them throughout the discussion. But if we are not able to get to them during the moderated portion of the discussion, there is Q&A at the end, and we will be sure to get to as many of your questions as possible. But with that, I just want to jump right in, and I want to kind of start us off by trying to understand what the status quo is of tech regulation kind of around the world. So Ramsha, if we can start with you, I was hoping if you might be able to start us off by providing a bit of a global landscape of the regulation of big tech. Obviously this discussion is centered around the US, but I'm wondering if you might be able to give us a bit of a global landscape of some of the most influential aspects of regulating big tech that are aimed towards respecting and protecting digital rights, because I know GNI is often at the center of those conversations. So it'd be great if you could kind of walk us through some of that.
Thanks so much, Eric, and pleased to be part of this amazing panel. It's a pleasure to be here and part of the forum itself. A bit broadly context of what GNI has been doing. So GNI's perspective is informed by over a decade and a half of experience undertaking multi-stakeholder collaboration to advance the GNI principles on freedom of expression and privacy, and the corresponding implementation guidelines, which together form the GNI framework and are rooted in the UN guiding principles on business and human rights and international human rights law. The framework provides guidance on how information and communication technology companies can build appropriate policies, systems, and capacity to advance responsible decision-making in response to government pressures, restrictions, or demands. So we have over 90 members at GNI, which includes press freedom groups, civil society, ICT companies, a lot of them based in the US, but also global, and also investors and academia working within the tech space. What we've seen in the past few years, also, like I said, GNI goes a long way back, is that around the world, countries are advancing new approaches to tech governance and regulation. Many are requiring tech companies and governments to provide certain kinds of information to the public, researchers, and relevant regulatory and oversight bodies. But an interesting trend that we're observing now is the shift from voluntary to mandatory legislation. Obviously, cannot not mention the European Union when we talk about regulation in tech. So major regulation from the European Union also elsewhere is shifting steps that companies may have taken towards transparency, risk assessment, human rights, and governance from voluntary to mandatory, which is now generating new incentives and has also been a focus at GNI. What we believe is that if properly informed by diverse and expert opinion and input, which is truly multi-stakeholder, these regulations have the potential to enhance meaningful transparency and also foster innovative, productive collaboration. What we don't want is to see a lot of tick box exercise or unintentionally create precedents that less democratic governments can exploit or establish burdensome requirements that impede collaboration and limit competition within the tech space. In some measures that GNI has been taking to improve and provide guidance on these developments is one called the Action Coalition on Meaningful Transparency, which was organized under auspices of the Danish government's Technology for Democracy initiative. The act is guided by a civil society steering group, which includes GNI and several members, including CDT. And we've been seeking to align and avoid duplication of a lot of regulatory efforts, but also to center research and advocacy on meaningful digital transparency. We've also been dealing a lot with multilateral institutions. Recently, as we would be aware, there's a UNESCO proposal for platform regulation, and then there's also an intergovernmental process called the Global Digital Compact. So our overall focus is to ensure human rights-based approaches remain at the forefront, but we also avoid duplication or unintentionally creating a justification or a model for more restrictive approaches. Thanks.
Thanks, Ramsha. That's really helpful to kind of understand a little bit more of the global context. Emma, I'm wondering if maybe we can turn to you now, and you can help to provide us with a bit of understanding of the status quo of tech regulation in Washington. What are some of the current regulatory and legal mechanisms being used to hold tech accountable in the U.S., and how effective are they?
Yeah, it's a great question, and thank you so much, Eric and Hamla, for putting this session together. I'm really excited for the conversation. I would probably summarize what's going on in Washington right now as a lot of noise, but not a ton of action. We've had, I think we're hearing policymakers talk about the need to hold tech accountable in many different fora, from the White House to Congress, kind of throughout the courts across the states. But we don't have a lot of coordinated or coherent activity or movement. The United States still does not have a baseline privacy or data protection law. That's something that we obviously really need to get into place, and really should be an obvious top priority for any policymakers to provide some fundamental level of privacy protections for individuals about how their data is collected and used, but also just put some basic restrictions on what online services can and cannot do with user data. We also, last Congress, saw a lot of discussion about the need for competition and antitrust law reform, really look at people diagnosing the issue of a lot of concentration of power across major tech platforms based in the United States, and a number of different discussions and a number of different bills coming up proposing different approaches to competition law reform and reform in different sectors, but none of them were able to ultimately keep a bipartisan kind of base of support and solve some of the different problems around privacy and free expression that some of the proposals raised. There are also a lot of discussions going on about Section 230, the intermediary liability law in the United States. It's one of the broadest intermediary liability laws out there that shields online services from liability for what their users post or transmit or link to on their services, and provides a really broad kind of frame of protection and ultimately foundation for user speech online. There have been calls from both the Democrats and the Republicans in Congress, from both President Biden and former President Trump, to repeal Section 230, to change Section 230 significantly. But at the end of the day, the two political parties really want very different things out of doing that kind of content regulation online. Democrats are looking at what they see as a number of unaddressed harms and issues around disinformation and hate speech and harassment, and they want companies to be taking more aggressive action on those things, whereas Republicans tend to think that online services are already doing too much and already taking down too much information, blocking too much, suppressing too much, especially what they think of as conservative speech. So we're not really seeing a lot of movement on where changes to the intermediary liability framework could come from, because there's this sort of difference in goal that I think that the two parties want. One thing that we are seeing a lot of discussion around is online child safety. And we're seeing that not only in different federal bills in Congress that we can talk about more later if folks are interested in, but also across the states in the United States. So we see a number of different statutes coming up in states like Utah, creating a strict age verification regime and all sorts of limitations on what young people under the age of 17 can do with the internet, including a limit that it has to be access to services have to be turned off at 10:30 p.m. at night and can't be restored until 6:30 in the following morning unless parents go in and change some settings. A lot of the trends we're seeing in state legislation around online child safety involve a pretty serious component of parental surveillance of how young people are using digital technologies. And I know for a lot of civil liberties advocates, that raises enormous concerns, including about the safety of those young people and kind of recognizing that not every family situation or every family dynamic is healthy or one where it would be appropriate for parents to have that much of a kind of view into what kids are doing online. So I think as far as kind of the actual mechanisms to hold tech accountable, we have some things. We have, there are different sectoral privacy laws in place across different sectors like health and education. The Federal Trade Commission conducts investigations and is really trying to be a lot more muscular in how it kind of brings claims and charges against tech companies, and with ultimately the goal of entering into what are called consent decrees, kind of rules binding at least particular companies to taking on some pro-consumer activities or limits on what they can do. And we do see oversight in different forms from congressional committees conducting hearings, calling CEOs of different tech companies to account and to provide information and provide more information about what they're doing to Congress. But so a lot of those hearings can also end up being a little bit embarrassing for all parties involved when it's clear that members of Congress don't necessarily understand how services work and the answers coming from tech companies aren't necessarily very revealing or forthcoming. So I think there is a long way to go as far as accountability for tech in the US, but there's certainly a lot of discussion going on.
Certainly, yeah. I think many of us remember the sight of many senators from both sides of the aisle questioning Mark Zuckerberg and kind of what was an embarrassment for everyone. I don't think anyone looks good coming out of that. But thank you for walking us through a little bit of what's happening in Washington. It seems like trying to understand Washington these days, or maybe ever, is quite difficult. So that's appreciated. Evan, I'd love to turn to you now. It seems like in the US, there's a habit of letting big tech regulate itself. And I'm wondering, why do you think that is the case, and how has that played out?
Yeah, for sure. Thanks again for organizing this and for having me. And sorry, I'm joining from my phone and a little bit discombobulated today, but super glad to be here. I mean, broadly speaking, I would say that this is just an extension of kind of US capitalism doing its thing. And so I don't know that it's particularly unique to this sector or industry. This is sort of kind of the status quo in the United States in terms of corporations and their behaviors largely being overlooked, and corporations having tremendous ability to influence regulation and policy to their own benefit. And so I think it's important, though, that we recognize that part of what's happening in the US around tech is also kind of more broadly a story about, like I said, US capitalism and corporate power. So, for example, Emma mentioned the deeply embarrassing reality that we have no basic data privacy law in the United States. And I think it's important to name that is because not only are large tech companies like Meta and Instagram, or like Meta and Google lobbying against such a law, but basically every large corporation in the US, from Bank of America to Target to Walmart, are also lobbying against strong data privacy laws, because basically every company at this juncture has become, at least to some extent, a surveillance company. And so almost every large retail store and many other companies and services in the US and around the world have a strong vested interest in being able to continue the kind of unfettered commercial surveillance that is increasingly a huge part of their source of revenue and power. And so I think, in some ways, the fact that we're allowing big tech to regulate themselves, as you said, is just an extension of that broader story of the role of corporate power in corrupting what is supposedly a democracy here in the United States, but often doesn't actually function that way in any meaningful way when it comes into reining in corporate power. The other thing I would say quickly is that I think these large companies have benefited from what Emma described of kind of just being able to play the two parties off of each other and sort of get away with just disagreement as the reigning policy of the day. And what's so frustrating about that is that I think there actually is a lot of consensus around where there are thoughtful things that could be done to improve the situation. Privacy legislation is perhaps the most obvious one. And it's very frustrating to me that we continue to kind of go down these rabbit holes of like, well, what if we just tried again to think about allowing the government to dictate what speech can be allowed on these platforms? Maybe it'll work out this time, instead of moving forward with something like a privacy law where there's actually significant consensus and doesn't come with the enormous pitfalls that we know come with attempting government regulation of speech in the United States. So I'll pause there and turn it back over to the other great panelists. But I would say at a high level, this is not necessarily a story that's just about tech. It's basically a story about the failure of American democracy to rein in corporate power. And that's a story that's been going on, unfortunately, for decades or perhaps even centuries.
Yeah, thanks, Evan. Sad remarks, but necessary remarks, I think, for understanding the realities of the world we live in, and certainly a conversation around regulating tech in the United States. Talking about implications of lack of regulation, I'd love to kind of continue along this thread. And Emma, you're the director of a free expression project. Freedom of expression is obviously one of the most fundamental digital rights. And so I'm wondering if you could talk to us a little bit more about what lack of regulation in the US means for basic digital rights like freedom of expression, but also privacy and questions around equitable access, and how have those things been impacted by this lack of regulation?
Yeah, no, I think Evan really hit the nail on the head, calling it unfettered corporate surveillance as sort of the status of privacy in the United States right now. Because we have no general privacy or data protection law, we have just kind of grown up an internet industry that is premised on the idea of collection of user data. Folks might remember conversations around sort of the era of big data, back 5-10 years ago, where the clear idea coming from Silicon Valley was just like collect all the data and then figure out what you're going to do with it later. And that even turns in now to real questions around competition of, companies that have had decades now to amass enormous data sets, enormous kind of piles of users' personal information, are using that as the inputs for machine learning, developing more sophisticated machine learning and artificial intelligence tools. And so the lack of privacy legislation is the terrible gift that keeps on giving, as far as kind of creating a really distorted sort of online ecosystem. It's also led to the real emergence of a whole industry of data brokers and the actual kind of buying and selling of data about individuals and the amassing of profiles about individuals that can follow them around through every sort of phase of their life and affect their ability to do things like get a job or access credit or find a place to live and an apartment to rent. So the lack of regulation around privacy, I think, has been just an enormous detriment to the rights of people in the United States. And I think it also sort of primed the tech companies based in the United States to treat other people's data that way for as long as they could before data protection laws in other countries sort of stepped in. I would say on equitable access, that is one area where there's maybe a little bit of a brighter spot. I have been really pessimistic this whole time. We, through the course of the COVID-19 pandemic and some of the infrastructure legislation that the Biden administration was able to pass, they did put something like $48 billion towards improving connectivity across the United States, and that's actually being rolled out. So we are finally seeing some of the enormous disparities in access and connectivity beginning to be addressed. And of course, it's going to be important to make sure that funding is actually going to the places it needs to go. But that is, I think, a little bit of a bright spot and shows what happens when you can actually have the state coming in with something like funding and some rules around how that funding can be used to try to make sure it's directed to the people who really need it and would benefit from it the most. And then I would say on freedom of expression, the issues about regulation, I think, are kind of complex, because there is a part of me as a First Amendment trained lawyer that thinks, yes, lack of regulation is exactly what the Constitution calls for. The First Amendment says Congress shall make no law abridging the freedom of speech. And in effect, that's been a lot of how the internet has operated in the United States. Between the First Amendment and Section 230's very strong liability shield for online services being held legally responsible for user speech, that has enabled the creation of a pretty active and vibrant environment for online speech, because it has taken away those sort of legal pressures that can exist in, and very much do exist in other countries, of companies facing that risk that they will face fines or jail time because users have said something that the government doesn't like. And we see companies around the world kind of cracking down on user speech to avoid that liability for themselves. So that is something in the US that we have managed to avoid by having Section 230 on the books since 1996, 1997. But even still, we see a lot of different attempts to regulate content, especially in the past couple of years. We see laws coming up from different states, including Texas and Florida, creating laws aiming to regulate social media services, and in particular to try to really constrain their ability to take down or to do content moderation around content like disinformation or hate speech. Both disinformation and hate speech are typically protected speech in the United States, and these laws are coming at it from the perspective of, a company should never take down someone's lawful statement. And there are some ways in which that's an understandable perspective, but it also means that you would be tying services' hands as far as doing things like combating the hate and harassment that is absolutely exerts a chilling effect on other people's ability to speak or willingness to participate on a platform. So I see a lot of concern around those ideas that online platforms must act as common carriers or must carry different kinds of speech, because we know from so many different people's experiences and research that there is a real chilling effect of unaddressed abuse on different online services. And then I'd also point out that I think one of the real concerns that are raised, kind of merging some of these privacy and free expression issues together, are how can online services, especially advertising services, whether that's like Google's advertising system or Facebook's, on platform advertising, how can they use that targeted advertising to engage in things like discriminatory ad targeting or targeted disinformation? So I think that is another area where people really see some significant free expression risks and kind of threats to democracy from that kind of hyper targeted messaging that's used to try to foment hate and division in a country, or confuse people about when the next election is happening, or misrepresent different politicians' views. And so that's something where I think there's a lot of room for additional discussion about whether and how regulation could hold online services accountable for that kind of combination of tools, the data collection on the one hand, and then selling the ability to third parties to use those behavioral profiles to target specific information at people.
Yeah, certainly. There's so much to get in with any of those specific areas that you just touched on. And I'd love to bring Ramsha into the conversation again to try to think about the implication of the fact that big tech in the U.S. is by and large creating our global digital space that has a reach far outside the US borders. So Ramsha, I'm wondering if maybe you could speak to what that means for the world, that the United States is kind of not regulating many of these companies that, once again, have a reach far outside the US borders.
I would like to mention that where I come from is Pakistan, and while Emma was speaking, it brought back to me the conversation around Pakistan cybercrime law, which has been termed the worst law in Pakistan's history. It's piece of legislation, be it just 26 words like Section 230, that have a big influence in the rest of the world as well. And in undemocratic countries or authoritarian regimes like Pakistan, there's a big, they adapt and take excuses from countries like US or democratic countries where they're like, look, if they're going after tech giants, then we can too. But obviously, the process is not transparent. The provisions are not as comprehensive, and the way these laws are passed on are not as ideal as we would see in other countries or other regions like European Union. But it's important to consider the way how we frame also regulation of tech giants, and that whether and how we regulate them. And this is another thing that GNI has been witnessing a lot, is how on one hand we have these thoughtful approaches like the DSA, but then on the other hand there's also this really big uptick on adoption of authoritarian state-led top-down approaches to regulate tech. For instance, we're seeing such measures in Turkey, in Brazil, in a lot of global majority countries, Pakistan I mentioned, where they're adopting these measures, taking on from mostly the US and their debate on content regulation. And such restrictive models of state regulation risk more harms to human rights. Our recent statements on developments in Turkey, Pakistan, India, even UK are evidence of how we're pushing back on things which are negative from a rights perspective, while acknowledging the important role regulation can play and should play in addressing concerns about digital content and conduct. So these are things we need to, this dichotomy in the regulation debate is something we should consider, because a lot of countries are not going to invest or take so much time out to even think about the harms that their top-down state-led approach can have on human rights. Another thing that's important to mention is because of the predominance of US headquartered platforms in early stages, American norms have probably played a disproportionate role in setting standards practices in terms of services of platforms. So companies have, of course, since had many experiences and challenges stress testing this approach. They're broadening engagement with the human rights focus, but this evolution remains a learning experience with more progress needed. And which is a very critical thing at GNI, to bring the global into this perspective. Because a lot of these terms and services have been developed from a very American cultural point of view. So to bring global perspectives into this, also highlighting the importance of stakeholder engagement and local perspectives and contexts, and how do these values translate in other countries. And like I said, authoritarian regimes is something that should also be taken into account. Another aspect is also the evolving tech system. So even as new regulations respond to what has developed, we are also seeing that government action is proven incapable of keeping pace with emerging technology, unless that is to censor, surveil, block, or violate fundamental rights and freedoms. But there are still a lot of efforts underway to help the industry take in perspective from global actors mostly, develop standards on evolving tech. This could be the role of generative AI, which is a big conversation now, emerging tech, like Web3, for instance, as well. So I think all of this is creating a new space within the industry itself, where everyone is now looking for guidance, and it's a process. But one thing I would like to mention is that while, for instance, going back to the European Union, where the focus has increasingly been on risk assessments as a mandatory exercise, We should take into account that these process-based regulations don't place significant burdens on companies to make it as a tick box exercise or doing human rights due diligence just to be able to comply with mandatory obligations. They can also compromise on a lot of human rights work that companies are already doing, some of it part of GNI membership, the framework that I mentioned. And then again, another aspect is that even placing significant burdens on companies to identify legality of content or monitor users. Sometimes some countries have even proposed placing significant criminal penalties on local staff or even disrupting services altogether. So there are two very opposite approaches to regulation that we're seeing, and we need to strike a balance, which is not easy at all. So yeah, I think the important takeaway from this is that we try, as more thoughtful approaches come in, we also keep in touch what the not so thoughtful approaches are, but that they take into account important safeguards, they don't become a tick box exercise, and they foster collaboration as opposed to restricting human rights online. And EU is leading the regulation, but implications are likely global, like you also pointed out, and with the Pakistan example as well. So yeah, we need to look at it from its local and regional, national and local measures, but the implications are very global, and it's important to especially take into account the global majority perspective.
Rookie mistake there. I left myself muted. Sorry about that. Thank you so much, Ramsha. It's such an important note to remember that we're not just calling for regulation, we're calling for good regulation, and that's difficult to create. And there is a huge risk of creating bad laws and policies that will have horrible implications. And also so important to note the global implications and understanding the diverse and wide array of opinion throughout the global majority, and not just kind of pushing for US norms or with the EU leading the pack, European norms in kind of creating regulation that has such wide-reaching impacts. Things that I think are fraught when talking about big tech. And Evan, you've already talked about the problematic nature of US capitalism and the faults of US democracy. And I know we've already talked a little bit about antitrust, but I find myself wondering, are big tech platforms just too big? And it seems to me, and maybe to you all as well, that US antitrust laws have been insufficient in dealing with big tech. So, Evan, I'm wondering if I could hear your thoughts on that, and as well as maybe a continuation of what that means in terms of global implications, not just here in the US, but around the world.
Yeah, for sure. And I think I'm really glad that we are kind of including this part of the conversation, because I think in a lot of ways it's actually at the root of a lot of harms that are often misascribed. And so I think if you were to break the two types of regulatory frameworks that we've been kind of teasing out and talking about in this discussion, there's the thoughtful ones, as Ramsha just kind of described, that attempt to assess risk, that attempt to mitigate risk, that attempt to reduce harm, that attempt to give more power to users, more transparency, more accountability. And then there's the kind of separate set of proposals that fall into what I would consider more an authoritarian impulse. And to be frank, that authoritarian impulse comes from both sides of the political spectrum in the US. There are many I won't say on the left, because I don't consider the Democratic Party to be the left in the US, but there are many Democrats that would like to see more involvement of government in dictating speech that's allowed on platforms, as I mentioned. And I think broadly speaking, there's a misconception that the problem with social media platforms is that they allow people to speak, and that we ascribe so much of the harm of these companies to the speech that is on them. And there's obviously horrific, deplorable, harmful speech hosted on these platforms. But I think we often perhaps misidentify the flaw with these platforms as the fact that they actually allow a wide range of speech, when that's actually perhaps the best thing about them. And really the harm of them is the surveillance-driven business model that distorts that speech, that amplifies some of it while suppressing other of it with very little transparency or community control or input over what that looks like. And with the end result of generating profit for the company rather than generating thoughtful conversations or the types of national and international dialogues that we know we need to advance justice and equity across the world. So broadly speaking, I'd say the reason that we care about that is exactly as you said, because these platforms are too big. If we had many different options for social media platforms where we could build a large audience, organize, mobilize people, then we wouldn't care if Facebook or Meta, for example, mislabels Zionism as a hate term. Because we'd say, well, fuck you, Facebook, you suck. You don't understand what's going on. You are applying a racist and uninformed position to this moderation decision, but we're all just going to go over to this other cool platform that understands that opposing Zionism is not anti-Semitic. And there we go. But we can't do that because we don't have lots of options and alternatives, and because the largest platforms tend to act in concert. There is a misconception among the American right that white male conservatives in the United States are the most censored group of people on social media. We know from actual data and evidence that Arab and Muslim folks who live outside the US are in fact the most censored group of people on social media, followed closely by sex workers in the US. And that is a problem that we can't solve by putting more power into hands of these companies or asking them to use it more responsibly. That's a problem that we solve by reducing how much power these companies have in the first place and creating true alternatives that are not controlled by one single corporation, that are not as susceptible to influence by the US government and other governments, and that are resilient to both censorship and surveillance. And so I think there's real value in the concepts of decentralization and democratization of technology, even if perhaps entirely too much hype in the concept of what decentralized technologies might look like or which ones might be useful versus not. But I think moving away from the hyper-centralized system that we have now is essential for restoring true free expression and human rights online. And antitrust law is absolutely one way to do that. Fight for the Future doesn't endorse very many bills. We tend to be pretty skeptical of the US government's involvement in tech policy because it has tended to be pretty destructive rather than helpful. But we are strong supporters of both the American Innovation and Choice Online Act and the Open Net Markets Act, which are antitrust bills that could begin to break the monopoly power of these companies to set us on a path toward a world where we can say, Elon Musk bought Twitter. We're not thrilled about that. We're going to go somewhere else and actually have somewhere else to go.
Thanks, Evan. Yeah, really gets me excited to think about a better future for how we could be developing platforms that are better for communities across the board. But before I jump into our last round of questions, which gets kind of at what Evan was teasing at around opportunities for the future, I just want to remind our audience that you can put your questions in the chat, and after this last round of questions, we will go to a Q&A, and I can't wait to hear what the audience is thinking. But before we get to that point, I do want to know what are our opportunities for the future from the three of your perspectives. So Ramsha, I'll start with you, and I'd love if you could speak from the perspective of GNI's work as a multi-stakeholder entity that has helped to shape regulation in really proactive ways. I'm wondering if you can speak to some of the lessons learned and knowledge through that process, and if you think that there's something that can translate there in terms of creating positive U.S. regulation that is kind of along the lines of the type of good regulation that you were speaking to in your previous remarks?
Firstly, I would say it's a process. GNI has been doing this for a decade, and it's still a learning curve. So for an example, in 2019, acknowledging the numerous proposals and recently enacted content regulations globally, GNI produced a framework on content regulation to address concerns about digital conduct and content to protect human rights, which Emma was also closely involved with. And the principles and recommendations in the guidance that we developed then are still relevant and continue to drive GNI advocacy. So the content regulation piece that was formed based on an analysis using human rights principles of 20 government efforts to address various forms of human online harm related to user-generated content, and content regulation. And after extensive consultations in a wide range of jurisdictions with GNI members and outside stakeholders, including governments, GNI published a policy brief titled Content Regulation and Human Rights Analysis and Recommendations. This policy brief outlines certain concerns around existing efforts and identifies ways to regulate content in a manner that upholds and strengthens human rights. So as more governments consider proposals, including US, to address concerns around digital content and conduct, we strongly encourage that they incorporate the guidance detailed in the policy brief. Just to mention broadly the recommendations, so governments should conduct careful, public, and participatory deliberation on such proposals, including strong transparency and accountability measures for relevant oversight or enforcement bodies. The brief details steps governments can take to uphold the human rights principles of legality, legitimacy, and necessity, and proportionality that can underpin any restrictions on expression and ensure laws protect rights as content regulations increasingly touch on things like monitoring of users, law enforcement collaboration, encryption, and so forth. So we continue to reflect this content policy brief recommendations in our advocacy. More recently, GNI expressed concerns about efforts from governments, including the US, to ban completely or otherwise eliminate access to specific digital communications platforms. This was in relation to the TikTok ban in US. While governments may have legitimate concerns about the impact of digital content and conduct on specific platforms, completely blocking entire platforms or services or mediums or any products we find is necessary or proportionate response to such concerns. It's never. So we continue to encourage companies and members across the ICT sector to follow the steps detailed in our GNI principles in line with the UN guiding principles that are they're grounded upon to protect the rights of their users. And lastly, include it's like I said, it's a process, but GNI members commit to employ protections with respect to personal information in all countries where they operate. And they take steps to protect the rights of their users when faced with government effort to access user data. So in short, GNI's member, we continue to encourage GNI members to continue complying with the framework, adapt, and also based on the GNI model of assessments, continue to review the process because, like I said, technology is fast changing and the regulatory regime is also changing. And for governments, the content policy brief is a good model to follow. And through our advocacy, we continue to highlight ways that governments can do good regulation, but also what not to do when regulating.
Thanks, Ramsha. And thank you for the important work that I know you've done on a number of different pieces of legislation. Emma, I'm wondering if you can maybe tell us, from your opinion, are there low-hanging fruit, so to speak, in terms of what we could achieve in the US from a regulation standpoint?
Yes, I think the most obvious low-hanging fruit that Evan and I have both been mentioning is privacy legislation. Last Congress, a comprehensive federal privacy bill got farther than it ever has, and there's really no reason it shouldn't move forward. It had broad bipartisan support last Congress. It could have the same this time. They just need to bring the bill up, not monkey around with it, not make changes or water it down or weaken it in any way. And move that forward. It would be positive for across the political spectrum for every internet user and every person in the United States to have privacy law in place. And it would also mean that the US-based tech companies would have less room to kind of maneuver and keep some of their less savory data practices happening in the United States in ways that can still end up impacting the privacy of people around the world. I also think there's some interesting conversations going on about transparency and especially enabling independent researchers to gain access to user data that are held by tech companies. We still have so many questions about how the online information environment works, what the different sort of policies and rules and products and tools that different tech companies create, how they actually end up shaping our information environment, affecting users' rights, affecting our opportunities to seek information and make ourselves heard and understood online. And we need to understand all of this a lot better, especially the question of how are tech companies creating different interventions that are designed to address some of the risks that they might identify in a risk assessment. We see any number of times where an issue with content moderation on social media is raised, and then the platform responds saying, hey, we're going to do X, Y, and Z to try to stop the dissemination of hate speech or the kind of concerted attacks on this particular group. And then there's very little follow-up and very little ability to actually assess from the outside, did that actually work? Or was it other reasons that the situation on the service changed? So I think there's a lot that could really be done if we could get more independent researchers, both folks affiliated with universities and academic institutions, but also civil society and journalists. There are a ton of journalists out there doing really great data-informed research and investigative reporting, and opening up some more of that data to people from a lot of different backgrounds to do this research, I think would give us a much better grounding for what other kinds of law or policy interventions we might want to see. Of course, opening up user data to third parties raises significant privacy concerns as well. So it's something where I think there are a lot of conversations happening both in the US and especially in the European Union about what would a really serious kind of framework and set of institutions to guarantee the privacy and security of users' personal information while also enabling more research to go forward. I think that could be something really positive. In the US, I think we should probably pass a baseline privacy legislation first so that we could build something like a researcher access to data framework on top of that. But those are two areas where I think we could see an enormous amount of benefit, both immediately to users' rights and also to just informing us all and policymakers in particular about the online information environment.
Well, that's great. And I think, there's probably folks that will listen to this that are crafting policy and they've heard the argument, and soon we'll have a privacy law in the United States. But before we move it over to the audience Q&A, I want to have one more question for Evan. As somebody that leads targeted campaigns in advocating for change, what do you see as the most needed or strategic aims in terms of regulation and legislation?
Yeah, I would tend to agree with Emma that a privacy law is both the most needed and the most kind of accomplishable sort of legislative thing that we can get done. But I would also just remind everyone, that while self-regulation is totally a joke and insufficient, we as individuals do have power that we can exert over these companies. And we have successfully organized in the past to force them to change certain practices or address certain concerns. And so I'll just kind of give one example of that, that my organization, Fight for the Future, is focused on right now, that perhaps inspires others to think through sort of what some of their demands might be or what could be accomplishable. And so for us, obviously, there's been a huge kind of focused attention in the US around corporate data collection and surveillance in the wake of the overturning of Roe v. Wade, the legal framework that upheld and protected the right to an abortion and reproductive health care in the United States. We obviously, still think a privacy law would do a lot to help there. But absent any meaningful moving from Congress, we've been focused on simply demanding that large platforms that offer messaging implement end-to-end encryption by default on all messaging services. And so, for example, Meta offers end-to-end encryption on WhatsApp. Many people probably use that all the time without thinking about it or knowing about it. But right now, they do not have end-to-end encryption turned on by default on Facebook Messenger, which means large numbers of people are messaging each other on Facebook Messenger, possibly about activism or other sensitive topics. And all of that information is accessible to the company and thus to any government that sends the company a valid legal request for the contents of those messages. So that's one thing that we've been doing, is simply pressuring companies to offer end-to-end encryption by default as a way of protecting users' rights to both privacy and free expression, absent meaningful action from governments. We're also focused specifically on Slack right now. Many folks who are watching this, maybe your organization uses Slack. If Slack receives a subpoena for all of your communications, they absolutely will hand that information over to a state or federal law enforcement agency in the US, or potentially even to governments outside the US, depending on the types of requests and agreements that are in place. And so that's one really huge risk for organizers that use Slack as a platform. And that's why we've been focused on our Make Slack Safe campaign, pushing Slack to offer default end-to-end encryption to all users to protect those communications. So that's just an example of kind of other perhaps hope or optimism that we can push for these types of policies. And end-to-end encryption is a beautiful example of a technology that puts power back into people's hands that governments basically can't take away from us, as long as we can defend that fundamental right to write and run software on devices that we own. So I'll pause there, but that's just an example of some of the work that we're doing right now to, while we're waiting and demanding more thoughtful regulation from governments, we can also exert our own power to demand that these companies change their practices and to continue supporting and creating space for alternative platforms that already have a better either governance model or better technology built into them. I use Signal every day, probably lots of other folks here too. Just getting your friends onto a better platform is one thing that we can all do to improve the situation.
That's great, Evan, and I think a great plug. Everyone should be using Signal to stay safe with their communications if you are not. We have only about 3 minutes left, and we have a question in the chat that is a juicy one, and I think allows us to kind of dive into some of the most difficult aspect of this. So if everyone could give maybe a 1-minute response to this question, I think this is an apt way to close us out. But Tina, in their question, is kind of looking at the fact that looking to the U.S. to regulate can be problematic, as the U.S. is the global superpower and creates a very specific type of narrative in the United States. And we've already talked, Evan, you've talked about authoritarian tendencies of governments in terms of regulation, and RMRSA, you've talked about some bad regulation that has happened. So I guess I'm wondering, in closing this out, how do we push as civil society, as folks that are trying to push for positive protections for folks? How do we push in a way that does not play into the problematic power dynamics? And I know that's a tough one, but that's the challenge at hand. So if you all could give us some closing remarks around how can we make the best regulation that will serve the global majority, that would be great. And I will go ahead and start with RMRSA.
I'll keep this one short. I think the power of stakeholder engagement, truly stakeholder, is important because it's become sort of a buzzword at digital rights forums these days, multi-stakeholderism. But in order to actually incorporate what it actually means in effect and to be actually multi-stakeholder like GNI, I think there is a bit of strength there to bring back. And also, I would add that besides stakeholder and taking the voices of marginalized and vulnerable groups and truly global majority voices adds to important context. But then also we should not just something that I'm going to reiterate again that I said before was that just doing regulation is not the answer. Even if you have a thoughtful approach, the devil is in the details. So we need to be very comprehensive in our approach, inclusive and proportionate.
Great, thanks, Ramsha. Emma?
Yes, kind of building on Ramsha right there, kind of invoking the standards of international human rights law. I think that has to be the foundation of any of our advocacy in any country around the world, including the United States. We should only be promoting and pursuing policies that would meet international human rights law standards, right? That's our set of combined coherent global standards that we can all reference to and then try to work for regulation and policy in our local contexts, but that still kind of meets those standards and feeds back into that broader global conversation. And I think it's really crucial for advocates around the world to remain in conversation with each other, and especially to make sure that folks who are doing domestic advocacy in whatever country you're in, and especially in the United States, have those connections back out to people who are facing some of these same issues and challenges in their countries around the world. I will have conversations that feel like totally night and day with some different, advocacy groups in the US who are really just thinking about things from a US perspective and are proposing things that I know that shock me. And if I take them to, colleagues fighting for digital rights in countries around the world, like we should never give the government that kind of power. The way that will be abused is so obvious. And so I think there's a real opportunity for kind of continuing to build and strengthen connections across the many different kinds of civil society that operate, especially folks who are typically more domestically focused, to try to get more of that conversation about what are the policies we think actually could and should work in different contexts around the world, because those are the kinds of things we should be putting our weight behind and not being willing to kind of make the political trade-off on rights in our local context without thinking about how that might affect people if that same idea gets taken up in other countries.
Great. And Evan, can I go to you for our last comments?
Yeah, for sure. I'm going to say what Emma just said a little bit more meanly. I think that U.S. civil society groups need to get our heads out of our butts. I think that folks here in this conference and on this call should get more aggressive in challenging US-led civil society groups when they continue to support policies and proposals that would lead to tremendous harm across the global community, because otherwise they are going to continue having an outsized voice in these conversations and will eventually succeed in passing dangerous legislation that makes sense in a US context, but could tremendously harm global rights. So I think there is a need for accountability and holding large US NGOs to account when they continue to support authoritarian and dangerous policies. In terms of analysis, I'll just share that for us at Fight for the Future, we're continuing to investigate this idea of applying an abolitionist framework to our tech policy inquiry. So many people are familiar with abolitionist ideas in terms of how they relate to policing and prisons. We are now kind of trying to apply that same line of thinking to big tech and asking ourselves questions about what types of policies actually reduce the power of this institution that we would like to abolish and replace with something different, and which policies actually increase and entrench the power of a system or institution that we would like to abolish. That is what has driven us to focus in on things like privacy legislation, which we see as inherently abolitionist in nature, because it is about reducing the power that these companies have rather than demanding that they use that power more responsibly. So that's just a little insight into kind of a mental model that we are trying to use to ask ourselves these difficult questions about what to support and what to oppose. And perhaps it's useful to others as well. Whether you identify as an abolitionist or not, I think we can all recognize that if we are trying to get rid of something and replace it with something else, we should not push for policies that actually make it harder to get rid of that thing in the first place.
Great. Thank you. Great comments, I think, to end our discussion on. So once again, thank you so much to Ramsha, Emma, and Evan for such a really thoughtful conversation.